Now, it is the 19th of January, Tuesday, and today happens to be the second sitting of the Supreme Court on the 2020 presidential election petition. So now for today, we have what we call the pre-trial, and in the pre-trial, we are expecting that parties to this particular election petition will sit down and agree on the issues that should be looked at. Now, we do know that some party bigwigs have already arrived for both sides. Now, we do know that the Director of Elections, for example, for the NDC, Elvis Ifeyankra, is here. We do know on the NPP side, the campaign manager for the 2020 elections, Mr. McMenu, is in-house. Former Information Minister Kujupon Krumah is here. Chairman of the NPP himself, Mr. Freddie Blay, is here. And also the petitioner for this particular case, former President John Dramani Mahama, is also, in the chamber. Now, in a few minutes, the case will begin. So we will take you into the chamber proper to bring you, key developments that took place in today's sitting.
The Supreme Court on Tuesday denied the NDC's John Dramani Mahama an application for leave to serve the Electoral Commission with some 12 questions. The questions, according to lawyer for the former president, Chachu Chikata, were critical to streamlining the case for a speedy trial.
What we have sought in these interrogatories, in our respectful submission, will achieve the objective of narrowing down the issues before this court. And there are 12 of them.
The questions border on the conduct of the elections, transmission of results, and declaration of same as conducted by the Electoral Commission.
Question 4. Should I understand it to mean the mode of transmission of the result? Is that what you are referring to?
That is correct. Okay. That is correct. And related to that, we also have in 6 a very specific question. Did the National Communication Authority facilitate in any way the transmission of results to the headquarters of first respondent? Again, that's a very specific question as regards whether the National Communication Authority facilitated in any way the transmission of results to the headquarters of first respondent.
Lawyers of the Electoral Commission, however, vehemently opposed the application.
My lords, we are opposed to this application. Lords, we rely on all the depositions in our affidavit. The answer to the question are in the petitioner's own petition. The answer filed by first respondent. We would also realize that the questions posed seek to introduce through the back door new facts which are not anywhere in the petition before this court.
So did lawyers for President Akufo-Addo, who, though not directly affected by the application, said they wanted to assist the court on the matter.
A matter that may be refused in interrogatories may be allowed during cross-examination. So our position is that all the issues that they are raising here, and if you look at the pleadings, are not in contention. We have been sufficiently answered. There may have been admissions which put them out of contention. And the petitioner may have his occasion during cross-examination to throw some of these questions at the EC.
The court, in its ruling read by its president, Chief Justice Enin Yeboah, said the application by the petitioner did not sufficiently address the question of relevance.
Subsequent statutory amendments pointed out after 2013 have provided us with new procedural regime and strict timelines. We are strictly bound to comply with CR 90 and therefore we will not apply Order 22 of CR 47 of 2004 in these circumstances. We accordingly refuse to grant the application and same is accordingly dismissed.
Lawyers for President Akufo-Addo, as well as that of the Electoral Commission, say there can be no delays in the trial. Mr. Chachu Chikata, however, had reservations with questions that his side was trying to delay the case. But is Jean Mensah being targeted as a person in this election petition? Is there a deliberate attempt to smear the chairperson of the election management body?
Mr. Chikata, why wouldn't you limit?
I'm sorry?
Why wouldn't you limit your references to the EC to the office, the chairperson, rather than the personality? It seems to me that your attack is against the personality of the person and not the office. So we'll be happy if you just limit it to the chairperson of the EC, because in her absence, any of the deputies, anybody at all could step in.
Respectfully, my lords, there is only one returning officer for the presidential elections.
And that is
that returning officer is not the EC. That returning officer is the chairperson of the Electoral Commission.
And that chairperson, that's all. We are not interested.
The chairperson has a name. I'm not able to mention the name of the chairperson.
The petitioners are expected to pick up the certified true copy of the court's ruling by close of day on Tuesday and subsequently file their issues by 9 a.m. on Wednesday. The first and second respondents are also expected to file their issues for the court to reconvene at 9:30 a.m. on Wednesday for a continuation of case management.
Proceedings for the day at the Supreme Court on the 19th of January has come to an end, and the parties are slowly trooping out of the chamber of the Apex Court. Now, the former President John Dramani Mahama has walked out with his entourage, and lawyers from the different sides are also trooping out. We'll try and get reactions from both sides with regards to what transpired today in the chamber.
Well, the real work in court has started. All this propaganda of having won 2 goals to 0. This is the first application that has formally been moved before the court. The application for interrogatories was dismissed outright by a unanimous panel of 7. This tells you that the petitioner has a long way to go insofar as this petition is concerned. There are ground rules which have been set for this petition, and the Supreme Court is not going to allow for unnecessary and interminable delays in the hearing of this petition. We are gladdened by the fact that the opposition we mounted was exactly what was rendered by the Supreme Court in its ruling.
The judiciary has changed the mode of election petition, the presidential election petition, to a stipulated time of 42 days. So we should not expect people to plead and go back and make additional amendments and all that, because it will be time consuming and time wasting.
So for you, I mean, the argument that indeed they are trying to delay the process, I mean, you actually ascribe to?
Yeah, sure. I mean, this case for me has to be done within a matter of days. So when people try to introduce new elements which are outside their pleadings, it should not be acceptable. Yes, it should not be acceptable at all.
What has happened is that you find that today that was set aside for case management. When the NDC came today, when Mr. Mahama's legal team came today, they introduced something new, a request for interrogatories, which was shut down. And now when the court said, we are coming back for why we are here, which is case management, they say they are not ready with their issues. They want up to Thursday to go and think through their issues and bring to the fore. And the court has disagreed with that. If you're a lawyer coming at this time, you must come with your issues. So 9:30 a.m. tomorrow morning, come and let's do the case management.
So you find that they came unprepared?
Well, it is obvious to everybody that the pleadings they have put out, they don't appear ready to set out the issues to back those pleadings. And the court is urging them that expedition is a matter. We have to be quick with this. So 9:30 a.m. tomorrow morning, bring your issues and let's go.
The Chief Justice said that given the new rules, that is CI 99, we could no longer bring an application for interrogatories in respect of election petitions. That really is surprising to a lot of us as lawyers, because basically what the court has done is to overrule its own decision in the 2013 election petition without according reasons as required by the Constitution and existing practice and precedent. We think that the court sidestepped the basic issues that were brought before it. We think that the issues were very relevant because they went, to they go to the meat, the integrity of the pleadings that were filed, that is the petition, as well as the respective answers. And in fact, if you were listening, counsel for the first respondent did admit that our interrogatories were relevant, because he said that those interrogatories raised issues that had been answered by their answer as well as the answer of the second respondent. And so for us, relevance was key to the application that we brought. And we're very shocked that the court did two things. First of all, by sidestepping its own decision in the 2013 election petition, that we think is very I don't want to use strong language, but I think that it is legally unacceptable, legally untenable. So we have requested for the ruling of the court, and we have told the court that we will advise ourselves with respect to the ruling.
So we have Dr. Dominic Ayene, part of the legal team of the NDC, essentially justifying why they filed that application. Now, at some point, the counsel for the first respondent mentioned that you're trying to use the back door to introduce some, questions and all of that. Is that the case? I mean,
in fact, there was no backdoor issue. Did the Electoral Commission not transmit results from polling station to constituency to region to their national office? So how can you say that a process to elicit answers to these questions amount to introducing facts through the back door? It cannot be. It cannot be.
No. The counsel for the second respondent says that these are some things you can do answers you can find in cross-examination.
So how can you? And now the court is saying that. Listen, carefully. Yes. The court is now saying it's not relevant. Meanwhile, the second respondent's lawyer says you can ask it at cross-examination. So which is which? Well, can you now ask a relevant question at cross-examination? Please.
We spoke to some key members of the legal team on the other side, and they were saying that today was supposed to be for case management. This application was brought up.
You say in any case, there are 5 days for the case management. So what are they talking about? Today is day 1. So what are they talking about? What is even key is that we have only filed for interrogatories. In some of these things that are happening are strange. In 2013, candidate Akufo-Addo brought interrogatories and it was granted by a 9-member panel of the Supreme Court. So what are they talking about? Akutampa was one of the lawyers. At that time, were they delaying the process when they filed that process? Please.
You have there Mr. Tamaklo essentially just sharing his thoughts about the ruling that was put out by the justices of the Supreme Court in response to the application made by the lead counsel for the petitioner, that's Chachu Chikata. So I'm going to bring in my colleague here, Sixtus Donglo, who has been sitting through today's session. Now, Sixtus, both parties have spoken and reacted to the ruling. I mean, from your perspective, what really transpired after you went in there?
Well, the court gave some reasons for refusing the application as sought by counsel for the petitioner. The question of the precedent which the court decided to distinguish. Again, the court said that the grant of such an application is discretionary. That means that the court can and will at any point in time, based on conditions that it considers or it deems fit, grant or refuse such an application.
So tomorrow morning 9:30 when we come in, what should viewers then expect to see? What are they looking at?
No, it's going to be a continuation of what we have seen today. The issues will be filed. In open court they will agree on the issues. It is possible that the petitioner, who is ordinarily the one who presents his issue, the issues are simply the set of questions that the court will be invited to adjudicate upon. And so the petitioner is the one conducting his case. He is the one to set out or propose the issues. In some cases, you find the proposed issues from the petitioner or the plaintiff, disagreeing with what comes from the defendant, in this case the respondent. You get it? And so where that happens, the court would have to step in and help the parties agree on the issues, and I'm sure that we are going to see some disagreement on the issues tomorrow. It could be one, they could be two, they could be three, they could be four. I mean, but at the end of the day, all the parties must agree that it is on this particular issue that we disagree. It is on 1, 2, 3 questions that we disagree, and so those become the issues for the trial proper. So I'm sure that tomorrow again we'll spend tomorrow looking at the issues and other concerns that have to do with the pre-trial.